All right, welcome back. Clearly, when it rains, it pours. Because after 3 months of nothing, at least in the DeCastro versus Abrams lawsuit, the Massachusetts suit, we finally have a new filing. And then a whole bunch of action in the DeCastro versus Peter, the California lawsuit. But that's all blue bacon related. So I think this is going to be a long one. So let's just jump straight into this. Let's do the Massachusetts suit first. So for those of you who are new here, and I have a feeling there might be a few of you for reasons, I'm Joe. I'm a lawyer based in Utah, so not Massachusetts, but that's okay. So our lolcow, Delete Lawz, Chili de Castro, has escaped captivity and he is becoming known to the wider world. And it's kind of strange because another of our lolcows, Cyrax, was just covered by Pyrocynical yesterday. So yeah, I feel like Kate and Masshole is sort of the vanguard of the up and coming lolcows before the big channels notice them. So why do I say our lolcows have escaped and I'm expecting maybe a few more viewers than usual? Well, because Delete Lawz may have actually added Charlie, Moist Critical, and GunnarTV as defendants in his lawsuit there in Massachusetts. So, for those of you who are just joining because you follow Gunnar or Charlie, um, I'm not going to do a full update of the lawsuit and where it stands. I'm just going to update what's new. So, go watch my previous videos. They're bad. Hopefully, I'm getting better. But I am going to sort of, since it has been 3 months, give an update. And the best way to do that is take a look at the docket. So, scrolling. The newest is the second supplemental complaint to the first amended complaint against all defendants filed by Jose de Castro on April 24th, 2023. So, if you recall, and I realize it's been quite a while, um, going, let's see, let's find it. Okay, so on January 12th, docket number 102, Judge Burroughs entered an order. Plaintiff's motion for leave to file a second amended complaint pursuant to Rule 15D of the Federal Rules of Civil Procedure, which was in 101, the previous day, is granted. Defendant's motions to dismiss, because remember, both Kate and Josh had pending motions to dismiss, shall remain pending, and defendants need not refile their motions unless ordered to do so by the court. Spoiler alert, I don't think the court's going to order them to do anything of the sort. Defendants nonetheless may supplement their motions to respond to any new allegations included in plaintiff's second amended complaint if they believe the legal arguments need to be supplemented in response to the new complaint. Plaintiff is advised that any further motions for leave to amend his complaint will be subject to more exacting scrutiny. Plaintiff, using the ECF e-filing system, should now file the document for which leave to file has been granted in accordance with the administrative procedures. Plaintiff must include leave to file granted on date of the order in the caption of the document. And then, in addition to this, remember in the first amended complaint, he added Google as a defendant. And Google does not have a pending answer or motion to dismiss or anything because they outplayed him and they said, hey, judge, can we wait to respond until after he files this amendment so that we're not duplicating our efforts? And the judge granted it. Now, Delete Lawz, and he actually is right here. He pointed out he did not ask to file an amended complaint. He asked to file a supplemental complaint. The judge has treated both of them as amended complaints, so that's where we are. The difference being an amendment is you change the complaint. The supplemental complaint is, here, judge, they've done more naughty things, so I'm adding causes of action that have happened after the lawsuit was initiated. So one of the problems he's going to run into, of course, is you can't add new defendants through a supplemental complaint. It doesn't work that way. But that's beside the point, because as far as the lawsuit is concerned, everyone except for Josh Abrams, Kate Peter, and Google are John Doe defendants. So that's where we are. Let's take a look at the second supplemental complaint. And bear in mind, this took 3 months. We waited on this for 3 months. 3 months. 3 months for this from the world's foremost constitutional law scholar. Over 3 months. Supplemental complaint. Pursuant to Federal Rule of Civil Procedure 15D, Plaintiff Jose de Castro, plaintiff, hereby files this second supplemental complaint to its first amended complaint, ECF number 62, and supplemental complaint, ECF number 79, in connection with its federal claim of copyright infringement. This supplement adds new claims for events that have occurred since the filing of the first amended complaint. Further, plaintiff supplements facts and copyrighted works, and alleges as follows. Introduction. Since the filing of the first amended complaint and supplemental complaint, all defendants, including unknown ones, have committed additional copyright and DMCA violations against plaintiff. Factual background. URLs of plaintiff's new copyrighted content since the first supplemental complaint are in Exhibit 1. I haven't pulled up Exhibit 1. It's just a list of URLs to his new YouTube videos since that date. Now, bear in mind, I haven't checked recently, but he has not registered any of these with the U.S. Copyright Office, which is a prerequisite in order to file a copyright claim, or at least a lawsuit. He does own the copyright to his videos. That's not in dispute. You own copyright to your creative works as soon as it's fixed in a tangible medium, video being one of them, or live stream. So he does own the copyright, but he has not registered the copyrights, which has to be done before suing. So I mean, that's an L right there for him. And that's without even getting into the fair use analysis. But supplemental to count 1, copyright infringement. Infringements of my copyrighted works have been published, including, but not limited to, at the following URLs, against all defendants. And we have a list of YouTube URLs. Now, I'm not sadistic, so I haven't opened all of those URLs. Luckily, Jim Finch did, and he put a list on his really cool site.org. And so going through, we have the videos are from Masshole Troll Mafia Official, Masshole again, Irish Demon, 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 Team Skeptic, Team Skeptic, Welsh News Network, Welsh News Network, Welsh News Network, Welsh, 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 Oleg Welch, not Welsh, Welch, Road Pirate Films, Dummy Kruger, Bridge the Divide, Potentially Criminal, The Plot Hole, Rich Grey Hat, Frauditor Reaper, GunnarTV, GunnarTV, and Moisty Reacts, which Moisty Reacts, I don't believe is actually run by Charlie. Charlie has stated multiple times his only clips channel is Moist Charlie Clips. This is Moisty Reacts, not Moist Charlie Clips. So this YouTube URL is not directly to Charlie's channel, but of course the alleged infringement would have occurred on Charlie's Twitch stream, so it's, in theory, he could go after Charlie and whoever runs this clips channel. Of course, he's going to lose either way. I mean, Charlie might have a claim against whoever runs this channel, but it's probably not worth his time to do so because he makes more money creating content than going after all the leeches that just chop up his streams and repost them without commentary. And then we have certificate of service, and I'm kind of disappointed because I was going to use this as a point in one of the filings for the other case. But let's see. I'm just going to pull up number 113 from the docket just as an example. And it's this section right here at the end. Certification pursuant to Local Rule 7.1A2. The court has waived this local rule for the remainder of this action. That's the meet and confer rule, which they've waived in this action because Delete Lawz is, well, he's a bully. He's a ill-behaved child, pathologically incapable of adult behavior. So Judge Burroughs said, you know what? Don't even bother. I have a feeling that Blue Bacon is going to have to ask for something similar, but we'll get to that later. So this is what's known in the legal profession as absolute garbage. Delete Lawz has still not learned that in order to prevail in a lawsuit, you've got to state a claim. I mean, he says it's copyright, but what's copyrighted? What's infringed? You've got to say, how many times has it been pointed out? At a bare minimum, you've got to say, for a copyright claim, Irish Demon, for example, since his videos, probably that one right there. Irish Demon in this video infringed on my video, which is right here. You can't just put a list and say, yeah, all of these against me. You've got to at least say this infringed because of this. Otherwise, you have failed to state a claim. For those of you who are new, our best friend, I have not pulled it up today because, well, I'm lazy. Federal Rule of Civil Procedure 12b6. It's a motion to dismiss for failure to state a claim upon which relief may be granted. That's what's going to happen here. And the judge is going to grant it. Because Rule 8, the Twombly and Iqbal standard, Twombly and Iqbal being the Supreme Court controlling cases as far as the pleading standards required to at least get a case started. You've got to lay out a set of facts. You don't have to lay out all the facts, but you've got to put sufficient facts in your complaint that the court can look at it and say, all right, assuming all of these facts are true, well, all these allegations are true, is there a claim in there that I can grant the plaintiff relief on? So if we're assuming all of this is true right here, what's the claim? There isn't one. I mean, we know he's trying to claim copyright, but the bare minimum under Rule 8 and 12b6 would be they violated my copyright of this video or this picture or this work through this video or this work. That's the bare minimum. And it's just not here. So this is going to be an easy decision for Judge Burroughs. I'm sure that she has enjoyed her time away from this nonsense. And for those of you who are new here, who haven't followed this saga through the Masshole or Delete Lawz channels, who only know of Delete Lawz through Charlie or Gunnar, Delete Lawz has done a number of videos. I don't know if they're still live or not, railing against Judge Burroughs, calling her Judge Sugar Tits, and just being absolutely vile. and then accusing her of watching his videos, which I mean, I hate to break it to him, but if you include the URLs of your videos in your pleadings, the judge can watch them. They're fair game. So if she knows that you've called her on air sugar tits and that she yeah, it's not a good look. Not a good look. So with that, I'm about to have, I'm sure, a massive drop in viewership because that's the end of at least what affects Charlie and Gunnar today. So if you were just here for that, thanks for joining me. Hopefully, do all the YouTubey things like, share, subscribe. Come join me next time I talk about this specific lawsuit and Charlie and Gunnar. But watch my other stuff too. I cover sovereign citizens from a legal perspective, but I also try to do other lawsuits, mostly in federal court because it's easy to get the documents from Pacer. I've, yeah, just come join me next time. For those of you who are sticking around, though, let's go to California. So, as you know, a month ago, Delete Lawz amended his complaint in the California case, and he added Blue Bacon and David Omo, which is Team Skeptic. Maybe not. Well, no, this is Blue Bacon's filing, so I assume that what's his name, Daniel Clement, is still involved, although Delete Lawz has had a hell of a time trying to get him served properly. Let's see. Did he add other people? Let's no. Either way, so we have here filed. What was it? On the 21st by Blue Bacon, the answer by defendant Piratini, that's Blue Bacon, to plaintiff by notice of demurrers and demurrers to, and notice of motions and motions to strike portions of plaintiff's first amended complaint. I've mentioned many times before, I'm a Utah-based attorney. I'm specifically not a California-based attorney. And I bring that up because, well, even aside from this is a strange caption to me, the demurrer is a strange motion to me because the demurrer is not actually available in most states. It is in California. It is not in Utah. So I have never and probably never will do a demurrer. And so it was abolished in federal court and in most state courts because most states follow the federal rules of civil procedure. Well, or at least they've adopted most of the federal rules of civil procedure as the sort of model for the state rules of civil procedure. I think I've mentioned before, I'm not a fan of California's rules of civil procedure. They're convoluted and awful. and not all found in one nice, tight package wrapped in a bow. You've got to look in several areas. I don't like that. And so California, not following the federal rules of civil procedure, as an example, has kept the demurrer, as has Virginia and Pennsylvania and a couple others. So I think the first thing we need to find out, what is a demurrer? Well, even though we don't have demurrers in Utah, they did explain what a demurrer is in law school, partly because it used to be available nationwide and in England because it's one of those ancient writs or motions. And so sometimes looking at old cases, you've got to know what something is, even though it's not available now. And so, like, we actually did talk about case law, I think federal case law even, where demurrers were filed. So we had to know what it was. And my civil procedure professor said a demurrer is basically the legal, it's the so what motion. It's so what? You're suing me? So what? And it's funny because I Googled demurrer, and I'm just going to do it on my phone because that'll be faster. And the Wikipedia page, the first paragraph, a demurrer is a pleading in a lawsuit that objects to or challenges a pleading filed by an opposing party. The word demurrer means to object. A demurrer is the document that makes the objection. Lawyers informally define a demurrer as a defendant saying, so what, to the pleading. So it's the so what motion. And I don't like, though, that Blue Bacon put answer by defendant Piratini by notice of demurrer. I don't like that he added answer because that could lead to problems, although this isn't structured as an answer, so the judge shouldn't construe it as an answer because it's clearly a demurrer. But the problem is, so an answer is the response of pleading. It's answering the complaint. And for an answer, you have to specifically respond to every allegation outlined in the complaint. So each numbered paragraph, you're going to have a corresponding paragraph. So, and you're going to admit, deny, or deny with explanation, or admit with explanation. So you basically are going to paragraph 1, defendant denies paragraph 1 of the complaint, and go all through it. And failure to deny is an admission. So that's something, I think that's where sovereign citizens get that, because they'll file their affidavits or send in their affidavits to the governor and say failure to respond is an admission and da-da-da. And it's not that's not the case in real life, but it is in answering a complaint. But like I said, Blue Bacon is not actually answering the complaint. He's demurring. And the demurrer was replaced by the 12b6 motion, which we mentioned a few minutes ago. the motion to dismiss for failure to state a claim upon which relief may be granted. Now, in proper civil procedure, you have 21 days to file a responsive pleading to the complaint. So you've got 21 days to answer. But the answer doesn't necessarily have to be the first thing filed by the defendant. You can file a 12B motion. It doesn't just have to be 12B6, but some of these you can file before the answer or with the answer. Some, though, some have to be the first responsive pleading. So a 12B6 has to be the first responsive pleading. So either it comes first or it comes as part of the answer. Whereas 12B1, a motion to dismiss for lack of jurisdiction, can be filed anytime. So it can be filed in the appeal to the Supreme Court at that time. Well, in theory, because jurisdiction has to exist throughout the whole case. So if you realize, hey, wait, jurisdiction's gone for some reason, you can then make that objection. Usually, though, you're going to make it at the start. So I'm going to say I like Blue Bacon. I watch his videos. I'm not overly impressed by his motions, but he's not a lawyer, so I wouldn't expect him to write like a lawyer. And frankly, looking at his writing, I'm not surprised that he's a former law enforcement. That he was a military police criminal investigator, so detective for the MPs. Because this reads to me kind of like a police report. It's formatting and structure, and this could be what California requires in state court, the formatting they require. Like I said, I'm not a California lawyer, and each court is going to have their formatting rules, but it seems wonky to me, but that's not a big deal. I'm not overly impressed, but that being said, if you recall, in the Massachusetts case, sort of the superpower, the power up that Delete Lawz has used is, I'm pro se, therefore you have to go easy on me, and you can't hold me to the same standard as Benjamin Wish or Joshua Garrick because they are attorneys. But I'm pro se, and I'm going to say that in every filing. I'm pro se. You've got to go easy on me. Well, so's Blue Bacon. So it's basically Blue has played the Uno reverse card or Delete Lawz. I'm pro se. You have to go easy on me. And Kate, although she hasn't answered yet, and Blue Bacon have basically played the Uno reverse card and said, we're also pro se. So you've got to go just as easy on us. And while I'm not overly impressed by Blue Bacon's motions, they are better than Delete Lawz motions. Not that it takes much. So with that, let's get into the body of the motion. Answer by notice of demurrers and motions to strike to all parties and their attorneys of record. Please take note that on August 1st, 2023 at 8:30 a.m. or as soon thereafter as the matter may be heard in Department O of the Superior Court of California, County of Los Angeles, respondent and defendant Michael Piratini, defendant Piratini, will and hereby does demur to and will and hereby does move to strike portions of plaintiff's first amended complaint pursuant to California Code of Civil Procedure, sections 430.10a and e, 435 and 436. The hearing on the demurrers and motions to strike will be held on August 1st, 2023 in accordance with Rule 3.1320 and 3.1322. I'm not going to be looking up the California rules of civil procedure because I'm lazy and I just want to steam through this. I will say the motions to strike are a bit weird procedurally. I don't think that's what I would have done, but the demurrers are made on the grounds that plaintiff's assertion of jurisdiction in paragraph 7 of his complaint is inconsistent with facts, and this court may therefore not have jurisdiction over defendant Piratini. All causes of action fail to state a claim against defendant Piratini upon which relief can be granted. The first, second, third, fourth, fifth, sixth, and eighth causes of action are known by defendant Piratini to contain misstatements of facts that have been presented to support the claims made, and all causes of action are written as plaintiff against all defendants, but fail to make it clear how all defendants are incorporated into the cause of action. Answer by defendant Piratini to plaintiff by notice of demurrers and demurrers to and notice of motions and motion to strike portions of plaintiff's first amended complaint. I hope that's a header for the section and not just a footnote, because that would have been awkward. It is a footnote. That's kind of awkward. The motions to strike are made on the grounds that portions of plaintiff's complaint contain irrelevant, false, or improper matter, and therefore should be stricken pursuant to California Code of Civil Procedure, sections 435 and 436. These demurrers and motions to strike will be, and hereby are, based on this notice, the attached demurrers and motions to strike, the memorandum of points and authorities in support thereof, filed concurrently herewith, the appendix of authorities filed concurrently herewith, all pleadings and papers on file in this action, and such argument as may be presented at the hearing. Based on the information filed, defendant Piratini rejects all claims against him that plaintiff has made in his first amended complaint. Dated April 21st, 2023, Michael Piratini. Now, if you are a pro se litigant, don't use herewith and it's just use plain English. Don't use convoluted language and try to sound like a lawyer. In law school writing classes, they're trying to beat this out of lawyers. Don't say in 10 words what you can say in 5. Don't use a fancy word where an easy word will suffice. It just use plain English. It makes things so much easier and more concise. And this isn't a criticism of Blue Bacon. This is just a generalized write in English. Unless, of course, you're in a German court, or, then write in German. Demurrers and motions to strike. Defendant Piratini hereby demurs to and moves to strike plaintiff's first amended complaint on each of the following grounds. And I mentioned I'm not going to pull up the rules of civil procedure, but there are a number of reasons for a demurrer, and one is lack of jurisdiction. Although that might be lack of subject matter jurisdiction, it might not actually be lack of personal jurisdiction, but as Blue Bacon is pro se, it'll probably be okay. Another of the reasons is if it's incomprehensible or confusing or whatever, which I think a lot of Delete Lawz causes of action are, so that's probably another. And spoiler alert, in Jose's demurrer, so the third of the 4 documents I have on screen, or tabs open for, he's going to argue that Blue Bacon has consented to the court's jurisdiction by filing this demurrer, which isn't the case, because that would be an oxymoron. So by demurring to jurisdiction, you're not consenting to jurisdiction, because that would be ridiculous. So, demurrer by defendant Piratini to jurisdiction and venue. Defendant Piratini is not a resident of California, and no action alleged to have been committed by defendant Piratini occurred while plaintiff was in California. California Code of Civil Procedure, section 430.10a. Defendant Piratini objects to plaintiff's claims that the court has any jurisdiction over him in this matter, as plaintiff has failed to establish the minimal contact defendant Piratini must have with the state of California. Demurrer by defendant Piratini to first cause of action, libel, slander, and false light, which technically should be 3 separate causes of action, but Delete Lawz is silly like that. The first cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. When the public figure doctrine is appropriately applied, the first cause of action fails to state facts sufficient to constitute a cause of action against any defendant. California Code of Civil Procedure, section 430.10e. So remember that this is the California state court equivalent of a 12b6 motion. This fails to state a claim upon which relief can be granted. Therefore, so what? Demurrer by defendant Piratini to second cause of action, battery. The second cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. Evidence exists that suggests the actions described in the second cause of action, when presented accurately, are insufficient to constitute a cause of action against any defendant. Once again, the California Code of Civil Procedure 430.10e. Evidence exists. Not here, it doesn't. But this is kind of a tortured sentence. But really, the first is plenty. All you need. The second cause of action fails to state facts sufficient to constitute a cause of action against defendant Piratini. Maybe add, defendant has not alleged any physical contact by defendant Piratini versus the plaintiff. Because he hasn't. It's not in the complaint. It's the only defendants he could possibly have this against would be Kate, but wouldn't you know that happened in Massachusetts, so that would be the proper venue. And I still think, assuming the statute of limitations has not passed, it's coming close because it happened on Memorial Day, and I'm guessing the statute of limitations for this would be a year. But I still think Kate should go to the Stoneham police and file a police report against Delete Lawz for battery over the Memorial Day parade incidents. Because the police witnessed it. They asked her if she wanted to press charges. She said no, because she thinks that would be a bitch move. But unfortunately, when you're dealing with someone like Delete Lawz, if you don't press every single advantage, he's going to. So if Kate had filed that police report, in this case, she'd be able to say, hey, look, he's accused of battering me. There is no claim here because he battered me. The police agreed with me on the scene. So you've got to take advantage of that when you're dealing with a fundamentally dishonest and scheming person like Delete Lawz. The other two possibly would be Daniel Clement for the Hollywood Boulevard incident, although that would be closer to assault, but I don't think would be that either. Harassment, maybe. I don't think there's a proper claim. It was dumb of Daniel Clement to do, but it's, I don't think, actionable. And even if it was, what damages has Delete Lawz actually suffered? And then J.L. Warren, Bridge the Divide for the Tahlequah, Oklahoma incident at the Deborah Rogers rally. That also is nonsense. So there is no battery. Demurrer by defendant Piratini to third cause of action, trespass. The third cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. That's all that was needed. Demurrer by defendant Piratini to fourth cause of action, harassment and civil conspiracy. The fourth cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. Hey, he's getting better at this. Demurrer by defendant Piratini to fifth cause of action, stalking, cyber stalking, and civil conspiracy. The fifth cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. It also fails to establish the elements required to constitute a cause of action against any defendant for stalking. Demurrer by defendant Piratini to sixth cause of action, assault. Same analysis as battery. The sixth cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. Evidence exists that suggests the actions described in the sixth cause of action, when presented accurately, are insufficient to constitute a cause of action against any defendant. Demurrer by defendant Piratini to the seventh cause of action, economic interference. Sick. The seventh cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. So I said I wasn't overly impressed. These are fine. These are fine. Demurrer by defendant Piratini to eighth cause of action, right to publicity torts. The eighth cause of action in the first amended complaint fails to state facts sufficient to constitute a cause of action against defendant Piratini. Demurrer by defendant Piratini to prayer for relief. The prayers for relief in the first amended complaint are not based on facts sufficient to constitute a cause of action against defendant Piratini. Well, they wouldn't be facts. They're not allegations. That's him asking the court, hey, give me this. So the motions to strike are where I start to get, really? Because at this stage, well, for starters, you're not presenting evidence of falsehoods. So the court's not going to strike anything, basically. This just isn't the time or the place. But we'll go through them just the same. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 1, page 1 and 2, lines 23 through 3. I'm guessing that would be 23 through 30 something. Of the first amended complaint's introduction, the words beginning, although plaintiff has been arrested many times, and ending, historically over 20 years old. The two sentences contained within these lines are incompatible. Plaintiff cannot claim to have a criminal record and claim he has not been convicted of a crime while protesting or otherwise. Plaintiff's statement of protesting or otherwise covers every possible action that could lead to a conviction. This statement is false and should be stricken pursuant to California Code of Civil Procedure sections 435 and 436. We know it's lies. The court at this stage doesn't care. Motion to strike portions of jurisdiction and venue. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 12, page 2 to 3, lines 25. I don't know how he's figuring the lines. 25-1. Or, okay, I get it. I get it. Never mind, I'm just being dumb. Page 2, line 25, through page 3, line 1. That would be the more proper citation, I believe. Page 2, line 25, through page 3, line 1. Otherwise, it just gets confusing. Of the first amended complaints, jurisdiction and venue, the words beginning general jurisdiction is proper and ending, and the harm occurred within that county, pursuant to California Code of Civil Procedure, sections 435 and 436. Many of the claims made by plaintiff occurred while he, the defendants, or both, were outside of the county of Los Angeles. This statement is false and should be stricken. We absolutely agree that these statements were false. Motion to strike portions of parties. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 12, page 4, lines 14 through 16 of the First Amended Complaints parties. The words beginning, Piratini is an agent of Peter, and ending, pretending to be a private investigator and military police officer, pursuant to California Code of Civil Procedure sections 435 and 436. Defendant Piratini is not an agent of defendant Peter, and plaintiff fails to establish otherwise. Defendant Piratini does not harass people, nor does plaintiff provide evidence to the contrary. Defendant Piratini is in fact a private investigator and military police. As these statements are false, they should be stricken. It's this whole we've discussed before. Blue Bacon is not an agent of Kate Peter. That's not how agency law works. We've discussed that on one video ago, 2 videos ago. Well, not 1 or 2 videos on this subject back. Probably in the video covering the First Amended complaint. But yeah, I have seen nothing to establish any agency among any of the defendants. I mean, in theory, my understanding is Daniel Clement went to harass Chile, and I say that colloquially, not as validation of Delete Lawz complaint, but he went there at the behest of the YouTuber Sovereign Soul Unchained Mind. So could be that Daniel Clement was acting as an agent of Sovereign Soul Unchained Mind for that incident. But Sovereign Soul Unchained Mind is not a defendant, so it's irrelevant. But either way, just saying, well, they're agents of each other, that doesn't establish anything. And unfortunately, we're going to have to come back to this in Jose's Demurrer. Motion to strike portions of first cause of action. Defendant Piratini moves to strike plaintiff's statement contained in page 5, line 20 of the First Amended complaint's first cause of action. The statement consisting of plaintiff against all defendants, pursuant to California's Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of the state of this state, as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike paragraph 20, page 6 of the First Amended complaint's first cause of action. Defendant Piratini did not title the video containing the alleged defamatory statements, nor did he make any of the defamatory statements alleged by plaintiff. The defamatory nature of the statement is, according to plaintiff, based on a been verified report, but defendant Peter, who published the offending video, had received information about the accusations from alleged witnesses and direct communications with LAPD. We know that's the case, but there's no evidence before the court that that's the case. So this isn't going to work for Blue Bacon. His demurrers, I think, have a shot. His motions to strike are unnecessary and just not great. Plaintiff has previously stated on record he took a deferment plea after being charged with possession and sale of narcotics. as well as manufacturing a controlled substance. The purported facts supporting the alleged defamatory nature of statements defendant Piratini did not make should be stricken for being false. The rest of the paragraph is irrelevant without those purported facts and should also be stricken. Defendant Piratini moves to strike the remainder of the first cause of action contingent upon the striking of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of this state and should be stricken. Motion to strike portions of second cause of action. Defendant Piratini moves to strike plaintiff's statement contained in page 7, line 12 of the first amended complaint's second cause of action. The statement consisting of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of this state as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike paragraph 30 contained in pages 7 and 8 of the first amended complaint's second cause of action pursuant to California Code of Civil Procedure sections 435 and 436. J.L. Warren, well, he says J.L. Warrant, it's J.L. Warren. I'm assuming that's an autocorrect mistake, is not a defendant in this case. The paragraph about his actions is therefore irrelevant and should be stricken. Defendant Piratini moves to strike the remainder of the second cause of action contingent upon the striking of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of this state and should be stricken. Motion to strike portions of third cause of action. Defendant Piratini moves to strike plaintiff's statement contained in page 8, line 11 of the first amended complaint's third cause of action. The statement consisting of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of this state as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike paragraph 33 contained in page 8 of the first amended complaint's third cause of action pursuant to California Code of Civil Procedure sections 435 and 436. Masshole members is not a defendant in this case, and unverified claims made by this entity do not establish the involvement of any defendant in this case. Based on these facts, this paragraph is irrelevant and should be stricken. Defendant Piratini moves to strike paragraph 34 contained in page 8 and 9 of the first amended complaint's third cause of action pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff describes a legal action alleged to have been committed by defendant Peter. This paragraph is not relevant to establishing any defendant to establishing that. You should have that there. Any defendant has met any elements of trespass, and the alleged facts of the incident do not match testimony he has provided to a different court. Based on these facts, this paragraph should be stricken. Defendant Piratini moves to strike paragraph 35 contained in page 9 of the first amended complaints. So, before moving on, if these facts don't match testimony he's provided to a different court, provide that as an exhibit. Let the court take notice of that. If it's the illegal recording he took of the Boston harassment prevention order hearing, provide that. If it's in the Massachusetts federal case, provide that. Just and say, see Exhibit A at, 4 minutes and 32 seconds through 6 minutes and 7 seconds, or Exhibit A at, page 7, line 4. Do that. Don't just allege it. If it doesn't match testimony, show in an exhibit why it doesn't match testimony. Defendant Piratini moves to strike paragraph 35 contained in page 9 of the First Amendment complaint's third cause of action pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff does not establish any defendant was responsible for the actions described, nor does the paragraph relate to trespass against plaintiff. Based on these facts, this paragraph is irrelevant and should be stricken. I'm assuming this is the Zaner, New Hampshire, or it might be the picture Kate took outside Zaner's building or whatever. Defendant Piratini moves to strike the remainder of the third cause of action contingent upon the striking of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of this state and should be stricken. Motion to strike portions of fourth cause of action. Defendant Piratini moves to strike plaintiff's statement contained in page 10, line 2 of the First Amended complaint, fourth cause of action, the statement consisting of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of the state as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike paragraph 38 contained in page 10 of the First Amendment complaint's fourth cause of action pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff describes an act by defendant Peter and claims it was defamatory and painted him in a negative light. The paragraph belongs in the first cause of action, but has not been improperly inserted, has been improperly inserted into the fourth. Based on these facts, the paragraph should be stricken. Defendant Piratini moves to strike the statement made by plaintiff contained in page 10, paragraph 38, lines 17 and 18, contained in page 10 of the First Amended complaint's fourth cause of action. The statement consisting of who is not a public figure or a limited public figure, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff is a limited purpose public figure, has stated he is a public figure, and the statement should be stricken for being false. Defendant Piratini moves to strike the statement made by plaintiff contained in page 12, paragraph 43, lines 6 and 7 of the First Amendment complaint's fourth cause of action. The statement consisting of the defendants work together in an agreement to commit these wrongful acts, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff's statement is both false and unsupported by facts and should be stricken. Defendant Piratini moves to strike the remainder of the fourth cause of action contingent upon the striking of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of the state and should be stricken. Motion to strike portions of fifth cause of action. Defendant Piratini moves to strike plaintiff's statement contained in page 12, line 9 of the First Amended complaint's fifth cause of action. The statement consisting of the plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of this state as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 57, page 15, lines 21 through 23 of the First Amendment complaint's fifth cause of action. the words beginning Piratini has been and ending at least November 2022, pursuant to California Code of Civil Procedure sections 435 and 436. Defendant Piratini has never sent plaintiff emails forged to look like they're from a court, and this false statement should be stricken. I'm assuming, I could pull up the amended complaint, but I don't want to. But I'm assuming this is Blue Bacon's trying to serve Delete Lawz with the protection order that he filed in Washington State Court, which was granted. We'll come to that later. Which Delete Lawz claims are forgeries, which that would be an insinuation that Blue Bacon's committing a crime of dishonesty, or, better be careful. Although that's a litigation privilege, and unfortunately for us, although if he's, on video, on live stream saying these are forgeries, then that probably wouldn't be under the litigation privilege. But we've discussed the litigation privilege, of course, in my coverage of the TikTok psychic case, Schofield versus Gillard, which I think is a lot more fun than this case, but gets a lot fewer views. So go watch that. It's a lot of fun. It's that TikTok psychic is nuts. And I should be doing a video on it tomorrow. It's surprising, but you'll have to wait for tomorrow's video. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 58, line 16, or page 16, line 7 of the First Amended Complaint's fifth cause of action. The statement consisting of the defendants work together in an agreement to commit these wrongful, illegal acts pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff's statement is both false and unsupported by facts and should be stricken. Defendant Piratini moves to strike the entirety of the First Amendment complaint's fifth cause of action pursuant to California Code of Civil Procedure sections 435 and 436. California Civil Code section 1708.7 requires a tort of stalking to prove a defendant violated a restraining order or issued a credible threat to the plaintiff's safety or the safety of the plaintiff's family, engaged in a pattern of conduct that caused the plaintiff to reasonably fear for his or her or for his family's safety, and the plaintiff on at least one occasion clearly and definitively demanded the plaintiff or the defendant cease and abate the conduct. Plaintiff has not established all elements have been met by any defendant. His claims are therefore not relevant to the tort of stalking and should be stricken. Defendant Piratini moves to strike any surviving portions of the fifth cause of action contingent upon the striking of plaintiff against all defendants, pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of this state and should be stricken. At least once he should have said how it's not in conformity with the laws of the state of California. Which laws? Motion to strike portions of sixth cause of action. Defendant Piratini moves to strike plaintiff's statement contained in page 17, line 2 of the First Amended Complaint's sixth cause of action. The statement consisting of plaintiff against all defendants pursuant to California Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of this state, as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 65, page 17, line 23 of the First Amended Complaint's sixth cause of action. The statement consisting of this stalker pursuant to California Code of Civil Procedure sections 435 and 436. Defendant Clement did not meet the required elements found in California Civil Code section 1708.7 to be the subject of a stalking tort. A claim that Defendant Clement is a stalker is improper and should be stricken. And as we've established covering the amended complaint, Daniel Clement is not Kate Peter. Daniel Clement is not Michael Piratini, nor is he David Omo, nor is he J.L. Warren or whoever else. So it's irrelevant to everyone except for Daniel Clement. Unless you live in Delete Lawz bizarro world where apparently everyone is everyone's agent, therefore everyone gets sued. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 66, pages 17 and 18, lines 24 and 22 of the First Amendment complaint's sixth cause of action. The statement beginning well down the block and ending begin an offensive defensive pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff's own video shows Defendant Clement did not corner him. Plaintiff's statement false and should be stricken. I'm not going to complain. I'm not going to criticize Blue Bacon for not having an is there because it happens. Defendant Piratini moves to strike plaintiff's statement contained in paragraph 67, page 18, line 10 of the First Amendment complaint's sixth cause of action. The statement consisting of stalk me pursuant to California Code of Civil Procedure sections 435 and 436. Defendant Clement did not meet the required elements found in California Civil Code section 1708.7 to be the subject of the stalking tort. Plaintiff's claim is improper and should be stricken. Defendant Piratini moves to strike the remainder of the sixth cause of action contingent upon the striking of plaintiff against all defendants, pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of this state and should be stricken. Motion to strike portions of seventh cause of action. Defendant Piratini moves to strike plaintiff's statement contained in page 18, line 13 of the First Amendment complaint's seventh cause of action, the statement consisting of plaintiff against all defendants, pursuant to California Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of this state, as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike the remainder of the seventh cause of action, contingent upon the striking of plaintiff against all defendants, pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of this state and should be stricken. Motion to strike portions of eighth cause of action. This gets tedious. Defendant Piratini moves to strike plaintiff's statement contained in page 19, line 5 of the First Amendment complaint's eighth cause of action. The statement consisting of plaintiff against all defendants, pursuant to California Code of Civil Procedure sections 435 and 436. This statement is not drawn or filed in conformity with the laws of this state, as plaintiff fails to establish each individual defendant's contributions to the cause of action. Defendant Piratini moves to strike the remainder of the eighth cause of action, contingent upon the striking of plaintiff against all defendants, pursuant to California Code of Civil Procedure sections 435 and 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of this state and should be stricken. Motion to strike portions of prayers for relief. Defendant Piratini moves to strike the entirety of paragraph 1 contained in page 19 of the First Amended Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish a defamatory statement was made by all defendants, and an injunction against all defendants for defamation would therefore not be possible. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 2 contained in page 19 of the First Amendment Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish a defamatory statement was made by all defendants, and the requirement for a declaration to be published by defendants would therefore not be possible. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 3 contained in page 19 of the First Amended Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish a defamatory statement was made by all defendants in an injunction for defamation against all defendants would therefore not be possible. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 4 contained in page 19 of the First Amended Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to outline the relevant provisions for this court. Based on this fact, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 5 contained in page 20 of the First Amended Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish all defendants have violated his right to publicity and has failed to take into account California Code of Civil Procedure section 3344D. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 6 contained in page 20 of the First Amended Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Just as an aside, this symbol I'm highlighting means section. So up here where I stumbled and said sections, you'll notice there's just one of the symbol. That means section. If you put two of them, that means sections. So you wouldn't put this symbol apostrophe S or this symbol S to denote multiple sections. You put two of these. And so sections 435 and 436. Fascinating, I know. Plaintiff fails to state a legal requirement for defendants to pay for his likeness or explain why the constitutional guarantee of freedom of press does not apply to publications about him. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 7 contained in page 20 of the First Amendment Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff fails to state a legal requirement for defendants to pay for his likeness or explain why the constitutional guarantee of freedom of press does not apply to publications about him. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 8 contained in page 20 of the First Amendment Complaint's prayer for relief pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish a defamatory statement was made by all defendants. And of course, it's possible that Delete Lawz in his amended complaint has all defendant instead of defendants. I'm just nitpicky. And relief for defamation would therefore not be possible. Based on these facts, this paragraph has not been drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 9 contained in page 20 of the First Amendment complaint's prayer for relief, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish the actual damages alleged and only attempts to establish damages caused by one defendant. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 10 contained in page 20 of the First Amendment complaint's prayer for relief, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish all defendants committed defamation and has not provided any evidence to support the amount of damages requested. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. The problem is that's a question to be established at trial if it makes it to trial. So, it's not going to be stricken. And that's the case with most of these. Defendant Piratini moves to strike the entirety of paragraph 11 contained in page 20 of the First Amendment complaint's prayer for relief, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has not provided proof that he is entitled to special or general damages. Based on these facts, this paragraph is with the law of this state. Defendant Piratini moves to strike the entirety of paragraph 12 contained in page 20 of the First Amendment complaint's prayer for relief, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has claimed all causes of action are against all defendants, so he must prove all defendants acted with oppression, fraud, or malice to recover damages. He has failed to do so. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 13 contained in page 20 of the First Amendment complaint's prayer for relief, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff is appearing pro per, and unless he can prove to the court he paid for the services of an attorney, he is not entitled to attorney fees, citing Trope v. Katz, 1995. That's an incomplete citation, Blue Bacon. You've got to, 135 Cal 7, 1995. Do the whole citation. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Defendant Piratini moves to strike the entirety of paragraph 14 contained in page 20 of the First Amendment complaint's prayer for relief, pursuant to California Code of Civil Procedure sections 435 and 436. Plaintiff has failed to establish he is entitled to damages and cannot be paid interest on something he is not entitled to. Based on these facts, this paragraph is not drawn or filed in conformity with the laws of this state. Dated April 21st, 2023, Michael Piratini. Put pro se or pro per under your name there. Come on, Blue Bacon. Ooh, hey. Oh, well, this is just the reservation for the court hearing on August 1st, which This motion cost $60, and the first paper fees of $435. California, your courts are extortionate. I mean, even without hiring an attorney, frivolous lawsuits cost an arm and a leg in California. This is ridiculous. California, do better. And I realize it's not just a California problem, but do better. Hopefully, Blue Bacon is able to recover costs. This is probably why Delete Lawz, one of the reasons Delete Lawz wanted to do it in California state court instead of federal court, because he's stated on video multiple times he doesn't care if he wins or loses, although I don't know if he's said it specifically about this case, but he wants to bankrupt them through attorney's fees, through legal costs. So this is just another way to do that. And it's slimy. So moving on, I'm less impressed. I haven't read through the whole thing. I've just glanced. But this is also filed by Blue Bacon. A memorandum of points and authorities in support of Defendant Piratini's demurrers to and motions to strike portions of plaintiff's first amended complaint. And like, filing a demurrer, fine. It's been said before, California has a very powerful anti-SLAPP law. SLAPP being strategic litigation against public participation. So, as far as Blue Bacon is concerned, the only actual allegations against him in here are defamation. And SLAPP, anti-SLAPP motions are made for defamation. I'm not an expert on anti-SLAPP laws. I've never filed one. I haven't looked up California. You've got to file it at the start. I wish they'd get there. And it's possible that it's still possible after a demurrer. But I would have liked to see that with the demurrer, because it wouldn't get rid of the battery claim or the trespassing claim, but despite Delete Lawz protestations, those are not against all of the defendants. It's ridiculous. So we have the table of contents, support for motions, plaintiff fails to establish jurisdiction, concerns regarding plaintiff's residency, lack of minimum contacts, plaintiff fails to state facts sufficient to constitute a cause of action, makes false, irrelevant, and improper statements. First cause of action, plaintiff believes he is a public figure. Plaintiff is a limited purpose public figure. Plaintiff intends to run for political office. Second cause of action, third cause of action, fourth cause of action, fifth, sixth, assault in journalism, eighth cause of action, prayers for relief, and a conclusion. Table of authorities, we've got Buckley versus Valio. Hey, Blue Bacon can cite the full case. That's a lot of Supreme Court cases. Gertz v. Robert Welch. International Shoe. Funny story, my friend in law school, first semester of our 1L year, we had a a Halloween party, and it involved a costume contest. I, well, my brother is a nerd, imagine that. And in high school, he made a full shirt and cowl or whatever you call it, head covering of chainmail. He made it by hand. It's ridiculous. So I wore that as my costume that year. I took second place in the costume contest. I'm still upset about it. But my friend, and I didn't get it at the time because I was in a different civil procedure class than him, and he we had not covered international shoe yet, but he he dressed as a passport and hung shoes around his neck, so he was international shoe. Um, and that's the landmark Supreme Court decision about the minimum contacts to a state to establish personal jurisdiction. And yeah, so Capellas versus Kaufman, Monitor Patriot Company versus Roy, uh, Ocala Star Tribune versus Dameron, New York Times versus Sullivan. That's the landmark Supreme Court decision on actual malice in order to prevail as a public figure in a defamation case. Trope v. Katz, Valdez versus Taylor Automobile. So, and I don't know that I like this motion even being filed yet. It's most of this I would have liked in the demurrer itself, although it's possible that California wants it this way. I like everything incorporated unless the rules specifically call for it otherwise. Defendant Piratini respectfully submits this memorandum of points and authorities in support of its demurrers to and motions to strike portions of all of plaintiff's first amended complaint. Support for motions. Plaintiff fails to establish jurisdiction. Concerns regarding plaintiff's residency. The address plaintiff lists as his address in this case matches the address used in a submission in case number blah, the California or the Massachusetts case, filed in the United States District Court for the District of Massachusetts on January 11th, 2023. However, plaintiff's former landlord stated he moved from that address to Nevada around November 21st, 2022. On September 23rd, 2021, a request for civil harassment restraining order was filed against plaintiff. The person seeking protection stated plaintiff was squatting at the Santa Monica address. On March 3rd, 2023, plaintiff published a video to his YouTube channel titled, "The Pigs Got Me Pulled Over." In that video, the address in Santa Monica can clearly be seen on a notice to appear issued by California law enforcement. If plaintiff was squatting at the address, he has no legal claim to it. Based on these facts, defendant Piratini does not believe plaintiff has a valid claim of residency within California. The problem with that is it's based on your domicile, and without getting too in depth, your domicile is sort of your residency, and you've got to have an intent to return, so like Delete Lawz despite his travels, his intention is to return. He hasn't changed his address from California. He hasn't changed his driver's license to Nevada or Colorado or whatever. So LA County is probably still his domicile. So he may be a homeless drifter and he may be in Nevada right now, but he probably still is domiciled in Los Angeles County. But moving on, lack of minimum contacts. Plaintiff makes allegations against defendants in paragraphs 20 through 26, 28 through 29, 30, 33 through 34, 36, 38, 39, 40, 41 through 50, 53 through 54, 56 through 57, 59, 69 through 71, and 73 through 76, should put of the amended complaint, incorporating the assertion that defendants were located in Los Angeles County at the time the alleged actions occurred. However, defendants would have been, I assume is what he's trying to say, outside of California during the allegations addressed in those paragraphs. The alleged actions committed against plaintiff in paragraphs 28 through 29, 30, 33 through 34, 49, 52 through 54, and 57 occurred while plaintiff was, by his own admission, outside of California. The events and allegations described in paragraphs 28, 29, 30, 33, 34, 36, 49, 52, 53, and 54 occurred when neither the plaintiff nor the named defendant was within the state of California. In the absence of those minimal contacts, exercising jurisdiction would be inconsistent with the Constitution. International Shoe versus Washington. Come on, Blue Bacon. I know you put it in the table of authorities, but the first time you cite it in the case, you've got to give the full citation. Got to do the whole thing. Subsequent citations, you can do the shortened citation. But here, you've got to do the whole thing. Plaintiff fails to state facts sufficient to constitute a cause of action, makes false, irrelevant, and improper statements. First cause of action. Only 2 defendants are named as alleged participants in these activities. Furthermore, defendant Piratini never made the claim that plaintiff has based his cause of action around, nor did he have any input on the title of the publication, which was a live stream and not an article as plaintiff has erroneously claimed. Plaintiff believes he is a public figure. On April 29th, 2022, plaintiff published a video to his YouTube channel titled Serving Public Info Request. In that video, he states, "I've only been on social media as you don't need to include his stuttering. We get it. As a public figure since June 20th of 2000. This statement establishes plaintiff believes he is a public figure and would therefore be subject to the actual malice standard defined as knowledge that a statement was false or with reckless disregard of whether it was false or not." New York Times versus Sullivan. Once again, full citation. Do it. Plaintiff is a limited purpose public figure. Even if plaintiff was not truly a public figure, despite his claims, he is a limited purpose public figure, defined as someone who has thrust themselves, I don't want to think of thrusting, to the forefront of a particular public controversies in order to influence the resolution of the issues involved, citing Gertz versus Robert Welch, Inc. Therefore, the actual malice standard would still apply. On March 29th, 2022, plaintiff published a video to his YouTube channel titled 12:50 p.m. Filing Lawsuits and Free Classes Today. Even free, his classes are overpriced. In which he stated, I'm going to set up my residency here because this is the corrupt town. Later in the video, plaintiff was arrested for trespassing in a government building while protesting alleged corruption in the city of Ironton, Ohio. On April 25th, 2022, plaintiff published a video to his YouTube channel titled, We Don't Stop, Ever, in which he stated, I don't have a criminal record. On April 28th, 2022, plaintiff published a video to his YouTube channel titled, Ironton City Council Meeting. In that video, a man identified as Kent Freeman told plaintiff townspeople used to show up at auctions with guns so that the auctioneers would be intimidated and farmers could buy their property back at cheap prices. Later in the video, plaintiff stated, let's have everybody go to the auction for these people's cars who were stolen on Saturday, and then let's show up in mass numbers, community unity, and make sure that only the person whose car was stolen bids on that car. I am failing to see why some of these were relevant and needed to be included. On April 30th, 2022, plaintiff published a video to his YouTube channel titled 9:45 p.m. We all meet at the Ironton impound lot. In that video, plaintiff stated, you know, I always carry a gun, and so tomorrow I will be carrying a gun. And I think that everybody else should carry. If they hold an auction, I don't think they will. I don't think they hold an auction. I really don't, because they know I'm not kidding. I can sue you, baby. I will sue your ass. I will help the people fill out their paperwork. I will sue your tow company. I will bankrupt your tow company. I will bankrupt the Ironton City Council. I will bankrupt it. Yikes. Talk about delusional. Knowing this, if we apply the Makeefe test to plaintiff, we discover 1. A public controversy of alleged corruption did exist when the statements were made. 2. The alleged defamation was a part of response to a false claim made by plaintiff during his participation in the controversy. And 3. The plaintiff voluntarily injected himself into the controversy for the purpose of influencing the controversy's ultimate resolution by publishing assertions that residents who acted against his will would be subject to lawsuits and armed intimidation. This confirms plaintiff should be considered a limited purpose public figure. C. Plaintiff intends to run for public office. On February 13th, 2022, plaintiff published a video to his YouTube channel titled, Police Are Our #1 Problem in America. In that video, he stated, and I'm never stopping. I'm not stopping until I win the governorship of California until 2026. And then we change the police system. On April 14th, 2022, plaintiff published a video to his YouTube channel titled, Let's Talk About Contraband, How to Fight for Your Stuff as They Arrest You. In that video, he stated, I'm not even in leadership yet. I'm not even in leadership yet in government. I'm not even the mayor of Ironton yet. I will be the governor of Ohio. That's a fact. On March 27th, 2023, plaintiff published a video to his YouTube channel titled Atwater versus City of Lago Vista, 2001. Any infraction of the law is arrestable and not a Fourth Amendment violation. In that video, he stated he would become governor of one of several states, would change policing, get rid of Supreme Court case law, and any federal agents who enter the state and enforce any federal law. Talk about delusion. These statements confirm plaintiff intends to pursue political susceptible to a higher level of scrutiny, and commentary about him is subject to a higher level of protection. A candidate for public office has no right of privacy as to the flow of truthful information which may be relevant to his qualifications for office, citing Capellas versus Kaufman. A charge of criminal conduct, no matter how remote, is relevant to a candidate's fitness for office. Monitor Patriot Company versus Roy. See also Ocala Star Banner Company versus Dameron. Discussion of public issues and debates on the qualifications of candidates are integral to the operation of the system of government established by our Constitution. The First Amendment affords the broadest protection to such political expression. Buckley versus Vallejo. I question whether, I think his presence on YouTube at least makes him a limited public figure, especially within the broad community, of First Amendment auditors and those providing commentary on First Amendment auditors and police watchers and police protesters. And within that community, he is at least a limited issue public figure. I question, though, at what point does the intention to run for office make you a politician? Because he's not currently running for office. So until he says, I am running for office in this election for this position in this year, that makes it more concrete. And, especially when he starts raising money for said run for office, or, files election paperwork, candidate paperwork. So I question whether he is yet, if ever, because he's never gonna run. He's a fart in the wind. Second cause of action. Plaintiff fails to name defendant Piratini and several other defendants. Defendant Piratini is aware of a video that appears to show the plaintiff battering defendant Peter, not the other way around. That would be the Memorial Day parade in Stoneham, Massachusetts. Once again, I think, assuming the statute of limitations has not passed, Kate needs to file a criminal complaint with the Stoneham Police Department. She may think it's a bitch move. That's fine. It would be to her benefit in this litigation. And for reasons we'll discuss later, Blue Bacon's restraining order, protection order against Delete Lawz could be used to Blue Bacon's benefit in this litigation. Third cause of action. Plaintiff states members of defendant Peter's Discord claimed to have stolen his van, despite referring to a police report naming a thief who is not one of the defendants. Plaintiff states a bag of dog feces was left on his porch and chocolate was placed on his door handle. But in a video published by the YouTube channel Dummy Kruger on September 23rd, 2022, titled Chili versus Kate and Josh, full court appearance, plaintiff told a judge the substance on the door was dog poop. On January 14th, 2023, plaintiff sent an email to defendant Piratini in which he stated, "You sent people to my family's home to serve you. Kate sent people to my house in Denver. Her trolls attacked my fight camp, got my Airbnb canceled." Plaintiff is referring to process servers defendant Piratini hired to serve an approved protection order to plaintiff while he was believed to be residing with family members. Plaintiff placed the blame on defendant Peter for the events in Denver, not defendant Piratini. It is unclear why that blame has shifted. Fourth cause of action. Plaintiff published his own phone number in his 12:50 p.m. filing lawsuits and free classes today video at 2 hours and 18 minutes, which may account for the unwanted telephone contact he received. Plaintiff's assertion that his phone produced audible alerts despite being in do not disturb mode appears unlikely, as one of his main functions of that mode is to prevent audible alerts. Plaintiff states he is not a public figure or a limited public figure. This has already been proven false, both by the legal definition and by plaintiff's own statements that he is a public figure. The success of many of plaintiff's claims may hinge on the claim of being a private figure, and if he is lying to the court about his status, it only serves to tip the scales against him in the frivolous intent of this lawsuit, if this lawsuit were to be measured. That's not a good sentence. Fifth cause of action. Paragraph 47 does not contain evidence of plaintiff's theory of an AirTag planted on or in his vehicle, and plaintiff fails to name defendant Piratini as someone involved in the alleged placement of an AirTag. Plaintiff owns a phone that can search for AirTags in, on, or around his property, and the fact that he has not included a statement regarding the use of that function in his lawsuit is concerning. Plaintiff also fails to establish defendant Piratini made any malicious communications to him about a tracking device. Countering plaintiff's claims in paragraph 48, plaintiff regularly reveals his location, intentionally or not, through his own publications. Merely identifying a person's location through open source intelligence is not actionable, and plaintiff has failed to establish defendant Piratini has participated in malicious communications of information made public by plaintiff. He also fails to establish defendant Piratini created any YouTube accounts to harass plaintiff, presumably because Piratini has never done this. In paragraph 49, plaintiff lists several states that are not California, despite previously claiming all unlawful practices were committed within the county of Los Angeles. He also repeats a vandalism and theft claim from the third cause of action. Discrepancies have already been noted with the vandalism claim. Plaintiff's stolen vehicle was not recovered from under a body of water. Defendant Piratini is not named as a participant in these activities. In paragraph 51, plaintiff denies the claim that he is a dangerous man who carries guns and is wanted by the police in multiple states. At this time, defendant Piratini is only aware of 2 active warrants in the state of Ohio that have been issued for the arrest of plaintiff. So, his claim that he is not wanted by the police in multiple states may have merit. However, among the messages sent to defendant Piratini after plaintiff published defendant Piratini's home address were these: "I want to meet you where no one can stop it, not at a public intersection where people can stop what will happen to you if you agree to meet me in the woods, or where there's nobody around and there's no cameras. Or I can show up at your house if you want me to. I'll sign a waiver. Then I can pick you up off the ground after, whoops, and you can get some medication and get your feet off the ground. And you can have your orthodontist on standby." This establishes plaintiff considers himself to be a dangerous person. Blue Bacon should have provided this email as an exhibit. And defendant Piratini was active duty military police for almost 6 years and continues to serve in the Washington National Guard. Plaintiff would need to be a dangerous person to cause enough harm to defendant Piratini that he would require an orthodontist and medication. On March 31st, 2023, plaintiff published a video to his YouTube channel titled "Nashville Cop's Body Cam Takes Out Shooter. 2A people equals people control. Rated PG, no violence." At approximately 21 minutes and 42 seconds, plaintiff Plaintiff stated, "I'm armed and my guns are loaded." Guns are loaded in multiple locations. Perhaps plaintiff isn't wanted by police in multiple states, but the other two claims should be considered accurate. Additionally, plaintiff has once again failed to articulate defendant Piratini's involvement in any actions described in this paragraph. In paragraph 52, plaintiff fails to establish that defendant Piratini participated in or encouraged leaving negative reviews on a business. Referring to the email plaintiff sent defendant Piratini on January 14th, 2023, plaintiff appeared to place the blame on defendant Peter's trolls for the alleged attacks on his fight camp, not defendant Piratini. And plaintiff has not provided any information in this lawsuit that explains why he would now believe defendant Piratini is responsible. In paragraph 53, plaintiff claims he was kicked out of his Airbnb in Colorado due to being a risk factor. Plaintiff denies he was armed in the Airbnb. However, the police report regarding plaintiff's stolen van states access to firearm. Yes. Referring once again to the email plaintiff sent defendant Piratini on January 14th, 2023, plaintiff placed the blame for the cancellation of his Airbnb on defendant Peter's trolls, not on defendant Piratini. Not only is it reasonable to believe plaintiff is in possession of a firearm, plaintiff names someone who is not a defendant in this case as the person responsible for Airbnb's actions. In a video published by plaintiff to his YouTube channel on August 18th, 2022, titled "Update, My Van Was Stolen, Federal Civil Rights Case, Fight Status," plaintiff states, "I'm stuck in Denver, Colorado at my Airbnb. I've rented this place until September 22nd. This would not be possible if plaintiff was kicked out of his Airbnb on August 1st and was unable to use his Airbnb account until December." That's a good point. The emails from defendant Piratini that plaintiff is presumably referring to in paragraph 56 were part of a court-approved method of electronic service of a protection order. Plaintiff knew the court paperwork was real. No other paragraphs in this cause of action contain any reference to defendant Piratini. Plaintiff claims this cause of action is against all defendants, but fails to name defendant Clement. Sixth cause of action, assault. In this cause of action, plaintiff outlines an event that focuses entirely on defendant Clement, despite stating the cause of action is against all defendants. Plaintiff states defendant Clement plotted to acquire plaintiff's firearm by force. It's possible defendant Clement had a real 18 U.S. Code section 922 G2 and 3, which establishes a fugitive from justice or an unlawful user of any controlled substance may not carry a firearm in interstate commerce. Plaintiff has publicly published videos establishing he travels across state lines to advertise, promote, and sell goods and services, and to create content. Plaintiff published a video to his YouTube channel on September 26th titled "The Corrupt Court, How Bad Is It? Let's See." And in that video stated, "I am overdue on a fresh bowl of marijuana, and I can't travel with any marijuana in my car." Plaintiff fled the state of Ohio to avoid prosecution and has not returned to Ohio due to warrants for his arrest. A YouTube video titled "Delete Lawz Loses Big in Court" was published by Law Talk with Mike on September 23rd, 2022, which showed plaintiff state, "I grabbed my gun. I was terrified. I was in Ohio. And then the next day, someone walked into my house. I put a gun to his head because I didn't know who it was," at approximately 10 minutes and 40 seconds into the video. Plaintiff published a video to his YouTube channel on September 25th, 2022, titled "Everything Wrong with This System. It Can Be Changed." His name was Ernest Aguilar. in which a revolver plaintiff was seen in possession of within Ohio is visible. Plaintiff was not in Ohio on September 25th, 2022. This information would have been available to any defendant and appears to establish plaintiff has met all elements of the relevant law. Any defendant may have reasonably believed it would be appropriate to conduct a citizen's arrest in accordance with California Penal Code Section 837. I don't like this argument. Citizen's arrest is never a good idea, unless, like, you see someone beating someone and, like, it's heat of the moment. And so, like, citizen's arrest generally is only allowed for felonies and, like, in active flight from said felony. So, and you have to have witnessed it as the citizen. So Daniel Clement, unless he saw the gun on Delete Lawz, there's no way he could make the citizen's arrest there. That would be false imprisonment. That would be bad. Trying to bait him into committing a felony, that's not a good look. I don't like this argument. I don't like this argument. And yes, a lawful citizen's arrest would not be assault. It wouldn't have. I don't see any situation where Daniel Clement would have made a lawful citizen's arrest. On October 16th, 2022, video published by plaintiff on his YouTube channel titled Sunday Night Hollywood Audits. The events described by plaintiff can be witnessed. Defendant Clement is seen filming Mr. DeCastro and communicating with him. Plaintiff was walking away from defendant Clement when he stated, "Well, I'm just telling you I'm going to go around this corner where it's dark. Come on, Dan." Plaintiff invited defendant Clement to follow him, but never walked around that corner. Plaintiff had multiple routes of egress that were not obstructed by defendant Clement, but he still decided to aggressively move towards defendant Clement and strike at him with his hand. This apparent assault, consummated by battery, which appears to have been committed by plaintiff and not by defendant Clement, can be seen at 1 hour, 36 minutes, and 8 seconds into the video. Journalism. In the video about Lauren Wickham, plaintiff stated, "You are a person of interest in a story that reached out through a third party, meaning I am a journalist. That gives me my right to follow you. And in a public space, you have every right to run up to her with your camera and your mic and ask her why she's a tyrant pig sucker, which is what I'm going to ask her when I see you in person, Lauren." Defendant Clement's actions appear to fall entirely within what plaintiff believes is appropriate behavior for a journalist. Delete Lawz misunderstandings of the law they're irrelevant. But as has been stated before, journalists do not have additional rights. If it would be wrong to do something without a camera, it's wrong to do it with a camera. If you are not allowed access somewhere without a camera, you are not allowed access with a camera. Now, sometimes the press may be granted access, but they're not guaranteed access. Delete Lawz does not have access to the White House press room. The White House decides which journalists are allowed. Same if I go to the Delta Center in downtown Salt Lake. I'm glad it's reverted to being called the Delta Center because I've been calling it the Delta Center since it was built, despite the two names in between, but it's returned to the Delta Center. But if I go down to the Delta Center during a Jazz game, I can't flash my homemade press pass and say, let me in, I'm sitting on press row, because I'm the press. The Jazz get to decide who is press for that game. Now, I can buy a ticket and sit up in the nosebleeds and write about it or, do a YouTube video about it at the end of the game. But the Jazz get to decide who has access as press. So, yeah. Eighth cause of action. Defendant Piratini's publications do not consist primarily of content about plaintiff. No contract existed that required money to exchange hands in order to publish content about plaintiff. A requirement to pay the fees that plaintiff is suggesting in order to publish newsworthy stories about a topic of public interest would be contrary to the First Amendment's freedom of press and cannot survive a facial challenge. In the video about Lauren Wickham, plaintiff stated, my YouTube account, my Instagram, my TikTok, my Twitter, every single platform that I'm on, Lauren, is growing exponentially. The website socialblade.com, which tracks YouTube channel metrics, shows plaintiff's channel has had 27,400 subscribers and 1,050,337 views 5 days before any defendant published content about him. 2 days after plaintiff filed his website, Social Blade shows plaintiff's channel had 67,800 subscribers and 7,198,316 views. Plaintiff does not make it clear how he has been harmed by a subscriber count that has more than doubled, and a view count that has grown by a factor of almost 7. In fact, in a video plaintiff published to his YouTube channel on 3/4/22 titled Blue Line Terror Flag, 1. Ban the desecrated flag gang symbol. 2. I'm a cop sucker. Plus DLZ clips all day. Plaintiff thanked another content creator for making hate video content about him, stating the video increased sales of plaintiff's products and subscribers to plaintiff's channel. Social Blade shows plaintiff's subscriber and view count was growing faster than normal around the time defendants and GunnarTV began publishing videos about plaintiff. It is unclear how his momentum would have suffered in the face of these statements to the contrary. And GunnarTV is irrelevant here, but that's okay. Prayers for relief. A. Paragraphs 1 through 7. Plaintiff's requests in paragraphs 1 through 3 of the prayer for relief cannot be granted if plaintiff has not established the defamatory nature of statements made about him. Plaintiff has failed to list the relevant codes and the way they were violated in paragraph 4. Relief for paragraphs 5, 6, and 7 cannot be granted. All content about plaintiff that was made by defendant Piratini was made solely for the purpose of criticism, comment, news reporting, and education. This content is protected by Civil Code Section 3344D, Section 107 of the Copyright Act, and the First Amendment of the Constitution. Paragraph 8. Plaintiff cannot be awarded damages sought. On December 25th, 2021, plaintiff published a video to his YouTube channel titled Lethal Lex Pending Lawsuit. In that video, he stated, "Do I need to sell more posters? Yes. Oh my God, yes. You have no idea. The other day, I sold 2 or 3 posters. I was ecstatic." He also stated, "If you don't have the $20, I'll give it to you for free. I sent off like 7 the other day. I sent out 20 today." On February 6th, 2022, plaintiff published a video to his YouTube channel titled Starts at 5:50 until 11:30. I challenge Officer Helmer to the 10-minute handcuff challenge. Email him. In that video, he stated, "I know that I have created a following to run for governor. I don't have any joy in it. I don't get off on it. Ugh. I don't want to think about getting off it. Ugh. On February 17th, 2022, plaintiff published a video to his YouTube channel titled, "You Just Got Pulled Over. Are You Ready?" In that video, he stated, "If it's all for ratings, if it's all for YouTube, then how come I've never come out of the dark before today? Why is that? And if it's all just for me making profit, why did I just give you guys a free code? Why am I giving my product away for free?" On December 18th, 2022, plaintiff published a video to his YouTube channel titled, "You Are Pulled Over by the Cops. Here's What You Do." In that video, he referred to one of his products and stated, "If you don't have $5, I'll give it to you for free." Plaintiff has established that, at the end of 2021, sales of his products were not substantial, and he often gave them away free of charge. Plaintiff states his channel is growing exponentially, but is not trying to make a profit and finds no joy in gaining subscribers. Metric trackers confirm his channel is, in fact, growing and did experience jumps in growth after content was produced about him. According to Valdez versus Taylor Automobile Company, a plaintiff in a tort action is not, in being awarded damages, to be placed in a better position than he would have been had the wrong not been done. Plaintiff has yet to provide clear or accurate evidence of his position prior to filing his complaint, and any prayer for past or future loss of income cannot be granted until he does so. Plaintiff may be the cause of his loss of revenue. On September 15th, 2022, plaintiff published a video to his YouTube channel titled, "Josh Abrams is hiding from service. It won't work. I'll serve YouTube soon," in which he addressed the following statement to people who supported defendant Peter. "I hope you burn in hell. I hope you burn in hell. And I hope your kids get bone cancer." On July 25th, 2022, plaintiff published a video to his YouTube channel titled, "Deborah Rogers Files Monster Motion. Judge T. Luke Bartrow. Here are the next steps." In that video, plaintiff stood with Rogers outside the Cherokee Nation District Court and stated he had spent a week helping Rogers work on a motion that she filed in that court. The motion was part of a lawsuit which sought to prove the Cherokee Nation was not recognized by the United States government. A ruling in favor of this argument had the potential to remove the indigenous status of 450,000 people. One might argue that wishing bone cancer on children and assisting in the attempt to remove the indigenous status of 450,000 people would have harmed his revenue greater than any statement made by defendants. This argument is unnecessary and just inappropriate here. This would be something to argue to a finder of fact, a jury, if it got that far, in establishing that there were no damages, that Delete Lawz caused his own damages. It's irrelevant at this stage. Summary. Plaintiff is unlikely to establish his revenue amounted to what he is requesting in his prayers for relief. According to CACI number 3903C, a plaintiff must prove the amount of income, earnings, salaries, or wages that have been lost to date, which plaintiff has failed to do. Plaintiff cannot be awarded the request relief without providing this information. Plaintiff cannot hold defendant Piratini accountable for an alleged defamatory statement that plaintiff has failed to show defendant Piratini made. Paragraphs 9 through 15. On August 39th, 2022, the Disciplinary Council of the Ohio Supreme Court sent a letter to attorney Paul Carroll, who had submitted a complaint against plaintiff, stating they believed plaintiff had engaged in the unauthorized practice of law. Once again, this letter should have been provided as an exhibit, probably with Paul Carroll providing an affidavit saying, yeah, I got this letter from the Supreme Court of Ohio Disciplinary Council. On October 28th, 2023, a video titled The Obnoxious World of Police Audits was published on a YouTube channel named GunnarTV. In that video, GunnarTV shared a clip from an unknown video published by plaintiff in which plaintiff stated, I have an education from Google and YouTube. I don't know anything more than anybody else. Defendant Piratini is prepared to present evidence that suggests plaintiff's economic relations mentioned in paragraph 9 may have suffered due to his own actions, which could include a lack of return for investors and a desire for investors to distance themselves from plaintiff's socially inappropriate and allegedly criminal behavior, potentially frivolous lawsuits, alleged unlawful practice of law, and the sale of a product that may be fraudulently misrepresented. Investors may have also discovered plaintiff fraudulent statements about his status as a constitutional law scholar to them. Fraudulent, though? I mean, we all know he's not a constitutional law scholar, but what is a constitutional law scholar? Something that vague can't be fraudulent. You know, if he said, I'm a constitutional lawyer, yeah, that's false. But a constitutional law scholar, what is the constitutional law scholar? Do you have to be a lawyer to be a constitutional law scholar? I'd argue no, because you can have a PhD in law. You can have a PhD focusing on constitutional law. Are they constitutional law scholars? I'd argue more so than me. But as I've said before, I would argue at any given time, there are a total of 9 constitutional law scholars or experts. And that would be the Supreme Court, because they get to decide what constitutional law is. Everyone else is just varying degrees of amateur. So, like the Attorney General for the United States, Merrick Garland, who before being Attorney General was nominated by President Obama for the Supreme Court. He was on the DC Circuit Court of Appeals, Federal Court of Appeals. The DC Circuit is kind of the most important of the federal courts of appeals. So, I'd argue Attorney General Garland is probably about as close as you get to being a constitutional expert while not being on the Supreme Court, along with, other circuit court judges and district court judges, but their opinion has even less merit because the circuit courts can overturn them. And lawyers are doing it. It's a pyramid, sort of. Not a scheme, just a pyramid of expertise. So I don't like this argument. However, plaintiff appears to only be directing this prayer for relief towards defendant Peter. Plaintiff seeks exemplary and punitive damages pursuant to California Civil Code section 3294 in paragraph 12. However, that code requires plaintiff to provide clear and convincing evidence that the defendant has been guilty of oppression, fraud, or malice. Plaintiff has failed to provide evidence that defendant Piratini is guilty of oppression, fraud, or malice. Once again, that's for a jury to decide. I don't like this. Plaintiff is appearing pro per, and unless he can prove to the court he paid for the services of an attorney, he is not entitled to attorney fees requested in paragraph 13, citing Trope v. Katz. Conclusion. Plaintiff fails to establish this court's jurisdiction over defendant Piratini, fails to state facts sufficient to constitute a cause of action against defendant Piratini, wrote every cause of action in a manner that was not drawn or filed in conformity with the laws of this state, and made many false statements in furtherance of his claims. This court should sustain defendant Piratini's demurrers and grant his motions to strike. Dated April 21st, 2023, Michael Piratini. Like I said, I don't like that this was two separate motions, basically. It makes it hard because basically what you're doing is you're looking at the demurrer and then comparing it to the argument in here section by section. I don't like that. Put your argument with the demurrer and do it that way, unless California requires it this way, which they could, because California courts are weird. Now, if you have a drink, now might be the time to get it. Because now we're looking at plaintiff's notice of hearing on demurrer, plaintiff's demurrer to defendant Piratini's answer and demurrer. Now, like I said 2 hours ago, demurrers are strange because, at least to me, because we don't have them here in Utah. They don't have them in federal court at all. But California still has them. Now, you can't demurrer to everything. You can file a demurrer to a complaint. You can even file a demurrer, although it's rarer because why would you usually, to an answer. Something you cannot demur to is a demurrer. Demurception is not a thing. But Delete Lawz is treating Blue Bacon's demurrer as an answer. But this is just poor procedurally. Delete Lawz probably should have filed something like plaintiff's opposition to defendant Piratini's demurrer. And you'll notice this is Piratini's to defendant Piratini's answer and demurrer. Let's go almost to the top. I realize Bacon's been, I don't feel like putting his address front and center, even though Delete Lawz wants to. This is not answer and demurrer. It's answer by notice of demurrers and motions to strike. I still don't like the way Blue Bacon titled it, but it's not an answer and demurrer. Oop, I was trying to. So I don't like it, but I like Delete Lawz even less. And his caption. Notice of hearing on demurrer. Notice is hereby given that plaintiff Jose de Castro, plaintiff's demurrer, which is set forth below to defend Michael Piratini's answer and demurrer. It's not an answer and demurrer. Filed as demurrer with motion to strike and memorandum of points and authorities on April 21st, 2023 has been set for a hearing on June 27th, 2023 at 8:30 a.m. or as soon thereafter as the matter may be heard in the courtroom in Santa Monica Courthouse, blah, blah, blah. Now, you'll notice Blue Bacon's demurrer is being heard on August 1st. The demurrer to that demurrer is being heard on June 27th. You don't hear the response before you hear the motion. That's not how this works. It's not going to work. And I really think Delete Lawz is being intentionally dishonest. You know, Piratini's answer and demurrer, quotation marks, answer, but it's not. It's a demurrer. And it's not answer and demurrer. It's answer by way of demurrer. He shouldn't have had answer in there in the first place, but it's not an answer. And Delete Lawz is really trying to get it treated as an answer, even though it's not. He's just fundamentally dishonest. Plaintiff demurs to the answer on each of the grounds set forth below. The demurrer is based on this notice of hearing on demurrer, on the supporting memorandum of points and authorities, and declaration of meet and confer, served and filed concurrently and incorporated here, and on the request for judicial notice served and filed concurrently, records in this action on the oral or argument of counsel, if any, and on such other and further evidence as the court may deem proper. That was a long sentence. Plaintiff's demurrer to answer and demurrer of defendant Michael Piratini. Demurrer to entire answer. But it's not. It's a demurrer which could have been prevented by Piratini conferring. Now, Delete Lawz is about to start complaining that Blue Bacon did not do a meet and confer, which is required by the local rules. I'm doubting Delete Lawz to meet and confer in filing this, but remember a little over 2 hours ago when I pulled this up from the Massachusetts case. Let's make it big. Certification pursuant to Local Rule 7.1A2. The court has waived this local rule for the remainder of this action because Delete Lawz was a dick to Benjamin Wish, Kate's lawyer. He was aggressive and refused to follow the rules. So the court waived the meet and confer requirement. I think Blue Bacon could have a good chance of having the same because Blue Bacon has a restraining order against Delete Lawz, which requires no contact from Delete Lawz. Blue Bacon can probably argue, it's not guaranteed to be successful, but he can probably argue, look, Judge, I have a protection order against him. He's not supposed to contact me. Full faith and credit clause in the Constitution means you've got to recognize this Washington judge and his rulings. So I don't want to meet and confer with this jackass ever. And frankly, requiring us to meet and confer is not going to streamline anything because he's a menace. Take judicial notice of the Massachusetts case where it's been excused, waived, and I'm not gonna pull a motion up. Not gonna pull it up, but let's find it. Emergency motion for hearing for a status conference by Kate Peter with the exhibits A, B, and C. Now, those are the ones with the emails and voicemails to Benjamin Wish, the "you're not my daddy." Have Judge Ford in Los Angeles take judicial notice of this as reason why meet and confer should be waived in this case. Plus, Delete Lawz, we're going to get to it, but Delete Lawz is demanding Blue Bacon's phone number. If I'm Blue Bacon, I say, Judge, I'm a protected party here. I have a restraining order that requires no contact. And you want me to give the party I'm protected from my phone number? That's out of bounds. I'd be happy to give it to the court so that the clerks can contact me if needed. But I want it under seal. I don't want him to have it. That's a violation. Of course, if the court forces Blue Bacon and says, no, you must, that's what Google is for. Create a Google phone number, use that. Don't give them your real phone number. All contact can go to the Google number. But continuing, plaintiff demurs to the entire answer, which isn't an answer, under Code of Civil Procedure, section 430.20b, because the objections and allegations of the entire answer are uncertain, ambiguous, and unintelligible in that, 1, Piratini generally misunderstands that plaintiff alleges that all claims apply to all defendants under the doctrine of agency. But that would be an argument in favor of Blue Bacon's demurrer, because what are the two relevant reasons for demurrer that we mentioned? Jurisdiction and confusion. Say, so what? This is confusing. We can't understand it. And Blue Bacon generally misunderstands what plaintiff means, and so that would be a reason to sustain Blue Bacon's demurrer. Whereas what would your Delete Lawz is demurring Is he saying it's not understandable that Blue Bacon didn't understand? That doesn't make sense as an argument. That doesn't work. Two, Piratini generally misunderstands the fact that the factual allegations by plaintiff in the complaint must be considered true at this point. 3. Piratini generally misunderstands how to object in an answer and instead attempts to strike factual allegations. I don't like the motions to strike, but that's fine. 4. Piratini tries to allege facts without any declaration or knowledge and belief and thinks that facts and allegations are points and authorities. 5. Piratini misunderstands subject matter jurisdiction versus personal jurisdiction. I mean, Blue Bacon didn't specify personal or subject matter jurisdiction, but he argued without specifying that the court has no jurisdiction over him, which would be personal jurisdiction. 6. Piratini misunderstands that each cause of action includes allegations outside of that section of the document. 7. Piratini misunderstands the concept of defendants listed as John Doe prior to discovery and misstates it as a joinder issue and doesn't cite any joinder subdivision of the rules. Piratini uses in conformity with the laws of this state 30 times in his document, but never cites any of the laws. In general terms, it's a hot mess. In general terms, Delete Lawz is a dick and needs to stop. I mean, I'm not a fan of Blue Bacon's, but once again, of his documents. I watch Blue Bacon. I like Blue Bacon. I don't like his documents. But Delete Lawz is still trying to treat it as an answer, which it is not. Plaintiff demurs to the entire answer under Code of Civil Procedure 430.2a because the answer fails to deny the material allegations of the complaint and contains no new matter constituting an affirmative defense. That's because it's not an answer. It's a demurrer. An answer would have to go point by point, but it's not an answer. And you demur because it doesn't have affirmative defenses. Well, affirmative defenses go in the answer, but the lack of affirmative defenses doesn't result in it being an inadequate answer, in you being able to demur to the answer. It just means those affirmative defenses are probably waived. But once again, this is not an answer. Plaintiff prays that plaintiff's demurrer be sustained with leave to amend, and that Piratini be ordered to comply with the rules of this court, including providing his telephone number on his filings and conferring with plaintiff before amending the answer. While plaintiff is patently interested in curing any defects in its complaint, there are too many issues with Piratini's answer that make it impossible to respond to. Memorandum of points and authorities. The special demurrer to the answer should be sustained because the answer is uncertain. That's because it's not an answer. The party against whom an answer has been filed may object to it by demurrer on the ground the answer is uncertain when the ground of objection appears to be the face of the complaint. Code of Civil Procedure sections 430.20b and A, or 430.30a, and California Trust Co. versus Gustafson. The term uncertain in this context includes ambiguous and unintelligible. Civil Procedure section 430.20b. The general demurrer to the answer should be sustained because the answer fails to deny the material allegations of the complaint and contains no new matter constituting an affirmative defense. Objection by demurrer. A party against whom an answer has been filed may object to it by demurrer on the ground that it fails to state facts sufficient to constitute a defense when the ground of objection appears on the face of the answer, or from any matter of which the court is required to or may take judicial notice. Civil Procedure sections 430.20a and 430.30a. Failure to state a defense. An answer that fails to deny the material allegations of the complaint and contains no new matter constituting an affirmative defense fails to state facts sufficient to constitute a defense. See Wheeler versus West and Lamar v. Superior Court. Denial of immaterial matter only. A demurrer to an answer that sets up no sufficient defense to the action and denies only immaterial allegations of the complaint should be sustained. See Wheeler versus West. If objections are to things not on the face of the pleading, the objection is an answer. When any ground for objection to a complaint or cross-complaint does not appear on the face of the pleading, the objection may be taken by answer. Here, many objections by Piratini were to things not on the face of the complaint, making Piratini's filing an answer, allowing for a demurrer. It's not an answer, it's a demurrer. So it's irrelevant. And if the court finds, you know what, this isn't a demurrer, it can say, this isn't a demurrer, try again. That's fine. But that doesn't make it an answer. Based on the foregoing, no, this is a conclusion. Based on the foregoing, plaintiff respectfully requests that this court sustain Piratini's answer with leave to amend and that Piratini be ordered to comply with the rules of this court, including providing his telephone number on his filings and conferring with plaintiff before amending his answer. Declaration of meet and confer. Piratini phone number on his answer as required by California Rules of Court Rule 2.111. One of my assistants did email Piratini without my direction, asking Piratini to email me his phone number or to supplement his notice. Instead, Piratini demanded conditions, including Piratini recording any calls and acceptance of liability if the number gets leaked. Piratini doesn't understand his requirement to make a phone number public record for this action. Instead of resolving any issues, we instead are left with an issue. We would ask this court to tentatively order that plaintiff did not fail to meet and withhold any 30-day extension due to the failure of Piratini or any other relief that the court sees fit. Once again, Bacon is a protected party from a Washington court. Of course, he hasn't provided his phone number. The California court may order it. That may violate the full faith and credit due to the Washington court. But Blue Bacon saying, hey, you're liable if it gets leaked, sounds reasonable. And the demand that Blue Bacon be allowed to record any calls, is also reasonable. Here's why. We know Delete Lawz records all his phone calls. He states he records all his phone calls, and that it can't possibly be wiretapping if he doesn't state, I'm recording this call at the state of each call in a two-party consent state, because it's known that he records all his phone calls. The problem with that is Blue Bacon is no idiot. He knows that Delete Lawz is recording the calls, whether Blue Bacon has granted permission or not. And he knows that Delete Lawz is fundamentally dishonest and is not above editing those recordings to make Blue Bacon look bad. So Blue Bacon is smart in saying, hey, if we're on the phone, I'm recording it because I need the full record to protect myself against your shenanigans that I know will ensue. So, but once again, if I'm Blue Bacon, not legal advice, but if I'm Blue Bacon, I'd probably be asking the court, hey, waive it. Waive rule 2.11.1. Meeting and conferring is not going to do anything productive. It's just another opportunity for him to harass me, the protected party. Did I mention there's a protection order, a restraining order? And a certificate of service and request for judicial notice. Plaintiff's request for judicial notice. Evidence Code section 452 provides that judicial notice may be taken of, among other things, records of any court of this state and the decisional law of any state of the United States. Plaintiff Jose de Castro hereby requests this honorable court take judicial notice of the following. 1. Demurrer with motion to strike and memorandum of points and authorities filed in this action on April 21st, 2023 by defendant Michael Piratini, specifically that these documents don't contain a motion and do contain an answer under California Civil Procedure 430.30b, that an answer in action waives personal jurisdiction. It has long been the rule in California that a party waives any objection to the court's exercise of personal jurisdiction when a party makes a general appearance in the action. Roy v. Superior Court. A general appearance operates as a consent to jurisdiction of the person. Section 1040 reads in part, a defendant appears in action where the defendant answers, demurs, files a notice of motion to strike, files a notice of motion to transfer pursuant to section 396B, moves for reclassification pursuant to section 403.040, gives the plaintiff written notice of appearance, or when an attorney gives notice of appearance for the defendant. The statutory list of acts constituting an appearance under section 1014 is not exclusive. Rather, the term may apply to various acts which, under all the circumstances, are deemed to confer jurisdiction of the person. A defendant may appear in ways other than those specifically designated in section 1014. Thus, whether a party engaged in an act that amounts to an appearance is fact-specific. That's it. It's fact-specific. He's asking the judge to take judicial notice of something that is fact-specific. And wants, finally, number 3, that Piratini has waived personal jurisdiction in this action. Dated April 26th, respectfully submitted, Jose de Castro, in pro per. Yikes. The problem with that argument let's say the court doesn't have jurisdiction over Blue Bacon. How is Blue Bacon supposed to tell the court, you don't have jurisdiction? Does he demur? Say, hey, so what? You don't have jurisdiction. Get lost. That's what he did. Or do nothing and not submit to the court's jurisdiction, just not respond. He hasn't assented to jurisdiction, but then he's going to have a default judgment, and he's going to have to go into the court and say, hey, judge, you don't have jurisdiction over me, and therefore... So it's an oxymoron to say you responding to say you don't have jurisdiction, grant jurisdiction. Otherwise, there's no way to tell the court it doesn't have jurisdiction. It doesn't make sense. None. So finally, we have motion without notice, meaning ex parte, to recover costs of personal service on Michael Piratini. Plaintiff Jose de Castro hereby moves this honorable court for an order allowing plaintiff to recover costs incurred in personally serving the summons and complaint on defendant Michael Piratini, pursuant to the provisions of California Code of Civil Procedure, sections 415.30 and 1033.5, in the amount of $145. This motion is based on the incorporated memorandum in support and incorporated declarations of plaintiff and the files and records in this action. Introduction. Defendant Piratini failed to respond after receiving a notice and acknowledgement of receipt which was mailed to him. So, plaintiff had to serve defendant personally, incurring the cost of hiring a registered process server and the cost of filing this motion. Accordingly, Piratini is liable for the cost of service incurred after his refusal to acknowledge service by mail. Code of Civil Procedure section 415.30 allows the plaintiff to bring this motion with or without notice. In this case, plaintiff makes this motion without notice. Factual background and declaration. On February 5th, 2022, Piratini posted a YouTube video of himself at 14805 blah blah blah, titled "Where's My Lawsuit, Chili?", where Piratini wondered why plaintiff hadn't served him in a harassment and defamation lawsuit yet. On February 6th, plaintiff filed this action for damages from defamation, harassment, and other torts caused by Piratini. On February 19th, plaintiff caused to be sent to Piratini at his address by first-class mail, postage prepaid, a copy of the summons and complaint in this action, copies of the Judicial Council's notice and acknowledgement of receipt of the summons form, the LA County ADR package, and a self-addressed postage prepaid return envelope. The address to which the documents were mailed was obtained from a November 2022 court action brought by Piratini, for which Piratini has not provided any new address. Would that be the court action that you claim is fraudulent? Plaintiff believed that the address to which the documents were sent was, in fact, Piratini's residence address at the time of mailing. The NARS and other papers were mailed by someone over 18 years of age and not a party to the lawsuit, named Matt DeCastro. Now, there's a general consensus that Matt DeCastro is an alias of Chili DeCastro and does not exist. Now, Blue Bacon, in defending this motion, there's other defenses, of course, might subpoena Matt DeCastro to appear in court to explain how he served Blue Bacon. Delete Lawz is unable to produce Matt DeCastro. That could be a problem. On February 27th, 2023, Piratini made a YouTube posting saying, "If anyone is claiming they have served me with a lawsuit, they are lying." On March 4th, 2023, Matt commented on Piratini's YouTube post, "If we don't get your acknowledgement by Friday 3/10, we'll have you served at work, and the first motion in the case will be to recover costs of service of process. Feel free to email the acknowledgement to Chili if you want." It was mailed 2/19. On the same day, Piratini did not ask which acknowledgement, but simply replied with, "I'm sorry, who are you?" On March 5th, 2023, Matt responded again on YouTube with, "I'm glad you didn't ask what I was talking about, but just who I am. Sounds to me like you know what acknowledgement I'm referring to, and that you're clear on how to avoid delaying things and having to pay for your own service. And it sounds to me like this is a third-party violation of the restraining order." On March 14th, 2023, Piratini recorded a 2-hour and 40-minute long video going over and reading plaintiff's first amended complaint. In this instant action, in a YouTube video titled, "Am I Finally Being Sued?" On March 22nd, 2023, ABC Legal Services completed substitute service of the original complaint, first amended complaint, list of parties, and ADR package at the address. On an adult after making 3 attempts at personal service, where the process server was lied to by a resident at the address saying that Piratini had moved. The cost of service was $85. See Docket, items, proof of service by substituted service, and declaration re due diligence, filed by plaintiff on 3/27/2023. Now, in some cases, that lie by Blue Bacon's roommate could be a problem, but Blue Bacon will have an easy explanation for it. But we'll get to that in a minute. On March 23rd, 2023, plaintiff verified that there were no records of the sale of the address after Piratini purchased it in 2020. Additionally, Piratini had just paid toward a past due sewage bill lien on February 22nd, 2023 for the address. On March 28th, 2023, plaintiff verified that there was no forwarding address in the National Change of Address database maintained by the United States Post Office for the past 2 years. On April 22nd, 2023, Piratini broadcast a YouTube video from the address titled, "Delete Lawz Won't Let Me Answer His Lawsuit," a 2-hour and 16-minute long video where Piratini admitted that a resident at his house lied about his moving. In the video, Piratini also admits to having received the NARS by saying, "He has, in fact, served me. He made some very weird attempts at service by mail, I think, that were so incredibly wrong that they could not possibly be considered lawful service." He goes on to say that he was going to try to quash the service from the NARS, but then plaintiff went on to hire a process server to have him served. Piratini was simply provided the official Judicial Council NARS form that provided the language to explain that if he did not return the acknowledgement, that he would have to pay for the cost of service. His inability to interpret the form or the reminder that Matt sent him are due to Piratini's inability to interpret plain language due to Piratini being a well-documented pathological liar. That's rich. That's rich coming from the fundamentally dishonest Delete Lawz. To someone with a personality... Oh! Wow. 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 To someone with a personality disorder like Piratini, who is always looking to manipulate the truth, Natural language is unfortunately full of semantic paradoxes. However, plaintiff's costs still need to be recovered, including the costs of service, which was $85, and the costs of filing this motion, which is $60, for a total of $145. Wow. And always looking to manipulate the truth. Natural language is unfortunately full of semantic paradoxes. Shall we look at this again? Answer by defendant Piratini to plaintiff by notice of demurrers and demurrers 2, and notice of motions and motions to strike. Answer by notice of demurrers. And then De Castro, plaintiff's notice to based on defendant's answer and demur. He straight up changes it, but Blue Bacon's the one that has a pathological personality disorder, and wow. Memorandum appoints and authorities. A service by mail and acknowledgement of receipt is permitted by Code of Civil Procedure, Section 415.30. Service by mail and acknowledgement of receipt pursuant to Section 415.30 requires only that plaintiff mails the defendant copies of the summons and complaint, with the request to acknowledge receipt thereof. If the defendant signs the acknowledgement, it waives further service of process. If the defendant refuses, some other method of service must be utilized, but the defendant is liable for the costs incurred. Plaintiff complied with Code of Civil Procedure, Section 415.30 to properly effectuate service by mail and acknowledgement of receipt. Required to be mailed to defendants are 1. A copy of the summons and complaint, 2. The notice and acknowledgement form, and 3. A return envelope, postage prepaid, addressed to the sender. Ordinary first-class mail of the foregoing is enough, and the mailing need not be certified or registered or return receipt requested. The notice must apprise defendants that unless he or she signs and returns the acknowledgement within 20 days, service will be made in some other manner, and the defendants will be held liable for the extra expenses so incurred. The acknowledgement must simply evidence receipt of a copy of the summons and complaint. An official form notice and acknowledgement of receipt has been adopted for mandatory use by Judicial Council. Use of the form automatically satisfies above requirements. Here, plaintiff complied with these requirements on February 19, 2023. Defendant refused acknowledgement and therefore is liable for plaintiff's costs of service. If defendant failed to sign and return the acknowledgement, service is not complete and will have to be made in some other manner. The notice form gives defendants a chance to avoid costs involved in effectuating service by some other method. Therefore, if they fail to sign and return the acknowledgement within 20 days after it is mailed, they become liable for whatever costs plaintiff incurred effectuating service by some other method, regardless of the outcome of the lawsuit. Nothing in the statute requires plaintiff to wait until the end of the case to obtain reimbursement of service costs. But is there anything that says you can obtain the costs of filing this motion before the end of the case? The statute says plaintiffs may obtain reimbursement on motion with or without notice to the defendants, and the court shall order such reimbursement except for good cause shown. Here, Piratini did not sign and return the NARS form, even though a postage prepaid envelope was provided. Thereafter, plaintiff was required to hire a registered process server to personally serve him at the address to where NARS was originally mailed, which cost $85. Plaintiffs are entitled to sanctions if forced to reply to this motion. Okay. If a party opposes a motion, arguments must be limited to those well supported by the facts and law. but that means he can argue those. It doesn't entitle you to sanctions for a good faith argument. He's in love with demanding sanctions. Under code Civil Procedure Section 128.7, presenting papers to the court creates a certificate of their legal and factual merit, and sanctions may be imposed for violation of this certificate. An attorney or unrepresented party who presents a pleading motion or similar paper to the court makes an implied certification as to its legal and factual merit and is subject to sanctions for violation of this certification. The purpose of the statute is to check abuses in the filing of pleadings, petitions, written notices of motion, or similar papers. In addition, a trial court could order sanctions under the Code of Civil Procedure for the filing of a frivolous opposition. Bad faith actions or tactics include opposing motions. Filing fees are recoverable costs. When a plaintiff attempts to perfect service by mail with notice and acknowledgement of receipt form, and a defendant fails to complete and return the form within 20 days from the date of such mailing, the defendant shall be liable for reasonable expenses thereafter incurred in serving or attempting to serve the defendant by another method. The court in which the action is pending shall award plaintiff such expenses. When personal service is made, the recoverable cost is the sum actually incurred in effecting service. Conclusion. Based on the foregoing, plaintiff respectfully requests that this court award costs to plaintiff for personal service of the summons and complaint after defendant's refusal to acknowledge service pursuant to Code Civil Procedure 415.30 and 1033.5 in the amount of $145, which constitutes $85 for service of process and $60 for filing this motion. Blah, 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 filed by Jose de Castro in pro per on April 24th, 2023. So, I raced through that, but here's the thing. Now, Blue Bacon may have messed up by live streaming, especially the live stream reading the complaint before he was properly served. Now, something to keep in mind, though, is once again, Blue Bacon is a protected party. So he receives mail or emails or comments from the name De Castro. Isn't it a reasonable assumption that it's an illegal third-party contact or even first-party contact from Jose de Castro, the party that is not supposed to be contacting Blue Bacon? So you have unsolicited mail showing up from De Castro. It goes straight into the round filing cabinet or unopened, but as evidence for the Washington court of violations of the restraining order. I mean, I don't know specifically what defects in service Blue Bacon is claiming, but arguing them is not de facto frivolous. Delete Lawz is trying to make that case already? That's ridiculous. That's utterly ridiculous. Saying if Blue Bacon even attempts to defend himself against this motion, that's sanctionable. That's ridiculous. It's utterly ridiculous. And then, you know, Delete Lawz says, well, the process server was thwarted because Blue Bacon's roommate lied and said he moved. His roommate was aware of the restraining order and a random person he doesn't know showing up saying, hey, is Blue Bacon here by chance? It's reasonable for the roommate to say, no, he doesn't live here. Because he knows that there's a restraining order. He doesn't know if this random person is Delete Lawz or sent by Delete Lawz. It's perfectly reasonable for him to say no. It's perfectly reasonable for Delete Lawz to not open mail from you or emails or any communication whatsoever. So that's where we are now. 3 hours, 15 minutes. It's a long one, but I feel like we covered a lot. Unfortunately, I've still got a long one that I keep promising, but keeps getting delayed because other stuff comes up. Because I still want to do the BitBoy crypto now that, especially now that we have resolution as to that issue. So the road ahead, gonna do the TikTok psychic case hopefully tomorrow. I'm gonna try. There's no guarantee. So update on that, Schofield versus Gillard. And then the BitBoy crypto. Who knows? We might have another flurry in the Delete Lawz lawsuits. So stay tuned. Do all the YouTubey stuff. Like, share, subscribe, bribe your friends to do the same. And I will see you very soon for the next one. Thanks. Bye-bye.